Hello, students. Yeah.
Waalaikumsalam.
Okay, so we got, yeah.
Salam.
So for today's class, we got 58 students. Okay, so I think the other two already dropped because they are not from, they are law students. They're supposed to join other group. Okay, so I hope everyone is in good health. So can we start the class so that we can finish earlier? Okay. So for today's class, our topic will be on industrial court and also labor court. Okay. So maybe you have been to court, or maybe you have assist your parents to court. Okay. So or you have seen a court. Okay. So industrial court and labor court is different from civil court. No? We got magistrate court, we got a high court, we got session court, we got did I mention magistrate, session, high court, okay, court of appeal, and also federal court. Okay, so that are civil court, nah? Okay. But here for the employment law, we are talking about industrial court and also labor court. Nah? Okay, so industrial court and labor court only deals with employer and employees relationship. Okay, so if you want to sue someone, let's say for breach of contract to supply goods, you cannot go to this court. Okay, if you want to sue someone, let's say for breach of sales and purchase contract, you cannot go to this court. So it's especially for employer and employee relationship. Okay, so remember that. Okay, you don't mention to anyone say that, okay, I've been harassed by my employee or employer. I want to file a case at the magistrate court. Okay, so the proper court would be the industrial court. Okay, so industrial court was established under Part 7 of Industrial Relation Act. Okay, so have you seen the act, or you already upload the act? Okay, can you see? I'm not sure. Can you see like this? This is the act. Okay, this is the act. It's not a textbook. It's an act. Okay. So please Google, and you can also download from the AG Chambers, AG Chambers in Malaysia. Okay. So the relevant provision is section 21 to 33B of the Act. So industrial court is not a court of law, but an arbitration body. It's a tribunal. Okay. So the formality is less if you compare with magistrate court or high court or session court. The formality is less. The documents are not very important. Okay. So it's like very friendly, friendly court. Okay. So we will look at provisions relating to the here the panel of the court. Now, who is actually normally in the court we have the magistrate court, we have the magistrate. If a session court, we have the judge. Okay, but for the industrial court, we call a person named president. Okay, so the president is the one who will assist the two parties for a case. So under section 21, the court shall consist of a president who has been appointed by, this is short form for our king, Yang di-Pertuan Agong. Okay, and there's also a panel, okay, panel of persons, that means more than one person representing employer, and also one panel representing the workman. Okay, all of this panel, okay, all the person in this panel shall be appointed by the minister. Okay, so we have the president, who is like the judge in the industrial court, and there's a two-party, okay, two panels sitting in the courtroom. Okay, the panel normally consists 3 to 5%. Okay, so one panel will be representing the employer, and the other panel will be representing the workman. Okay, the workman is the employee. Okay, so you can see how it looks like. Okay. So this is the organization chart. Okay. You can go to the Industrial Court website also to get this organization chart. Okay, so the president is here. Okay, you can see. Then there's a chairman. Okay, there are few chairmen. Okay, there's one in KL, and the other chairman is for the branch. Okay, Penang have Industrial Court, Perak have Perak. Then Johor, Sabah, and Sarawak. So you got how many here in Peninsular Malaysia? There's only four: Kuala Lumpur, Penang, Perak, Johor, and the other one will be in Sabah and Sarawak. Okay, there's a registrar which we call normally pendaftar. Okay, deputy registrar. Okay, and there are few units under the industrial court. So these are the organization chart. Okay. Okay, so the how the court look like. Okay, the court may sit in two or more division with the same or different chairman. Okay, so this is how the court will fix for the hearing. Okay, so the Yang di-Pertuan Agong may appoint any person to be the chairman of any division. Okay, so we have the president, and then the chairman will be for the different industrial court according to the state. Okay, so any division shall be constituted of a chairman and two members selected by the president. Okay, that means one chairman and two panel. The panel is where one for workmen and one for employer. Okay, the one that I mentioned earlier. Okay, then here, for the purpose of dealing any reference to the court under section 20 subsection 3 or any application reference to the High Court under section 33A, the division may be constituted by a chairman sitting alone. Okay, so in cases relating to references under section 20, because we have not gone through, this is only the second week. Later you know what is section 20. Section 20 is about dismissal. Okay, and section 33 is a reference to the High Court. The chairman may sit alone. That means he do not need the two panel to be there. Okay, so can you imagine? Okay, so the court may, with the consent of the parties to the dispute, act notwithstanding any vacancy in the number or absence of any member other than the chairman from any hearing or any part thereof, and no act or proceeding or award of the court shall be called in question or be invalidated by reason of such vacancy or absence. Okay, so you know that the court have the president. Okay, the president will be sitting in the middle, and by the side there will be two panels. Okay, so one panel got, let's say, got three members. Okay, so if one of the members is absent, okay, so the chairman can proceed with the hearing. Okay, so it says that the proceeding cannot be invalidated. That means cannot be what you call fatal. Okay, or it is not a good one because there is an absence of member. Okay, because the member is already more than one. So if one member is absent, it doesn't matter. Okay, but the chairman must be there other than the chairman. So the chairman must be there to hear if there's any vacancy or absence of any member. Okay, the case can go on. The case in the industrial court can go on. Okay, during the absence of the chairman, okay, let's say the chairman itself is not he's sick. Okay, he's absent. Okay, during the absence of the chairman, the Yang di-Pertuan Agong may appoint another person to exercise the power of the chairman. That means the hearing must go on. Hearing is perbicaraan. Hearing must go on with the presence of the chairman. If the chairman appointed is absent due to any reason, another person can be appointed as the chairman. Okay, notwithstanding, the chairman may resume the duties of his office. Okay, the person so appointed, the person who replaced the chairman may continue to exercise the power for the purpose of completing the hearing and determining any trade dispute or matter commenced before him. Okay, so if the chairman is absent, another chairman is appointed, he can continue even though the original chairman I mean he can go on with the work, but the law allow the replacement chairman to continue with the hearing until he has completed the hearing and he determined the case before him that he taken over from the original chairman. Okay, so far can you all understand?
Yeah.
Muhammad Firdaus, can you understand? Muhammad Firdaus,
Yes.
can you understand? Okay, yeah. So it's easy, yeah. So we have the chairman, and by the side there's a two panel sitting, one for the employer, one for the employee. The panel can be a few person. Okay, so it's not stated how many person. Normally it's like 3% or 5%. If one is absent or there's absence, it is also not stated how many can be absent. If there's an absence, okay, the case can go on with the chairman and also with the absence of the member of the panel. Okay, and if the chairman is not there, he's absent, another person can be appointed as a chairman. Okay, and that chairman can go on with the hearing. Okay, even though the original chairman already resumed the duties. Okay. Okay, so section 22(2), if any member other than the president is unable to attend any proceedings or cease to be a member, the president may select any member to fill in the vacancy. Okay, this is under section 22, subsection 2. Let me check. Section. Okay. So the president have the right to select any members to fill in the vacancy. Okay, so he have the, because if you want, if there's any absence, he can also appoint someone to be the member for the panel. Okay. Then section 22, subsection 3, the court may, with the consent of the parties, consent means with the, what do you call, persetujuan, I can say in Bahasa Malaysia, persetujuan, okay, act notwithstanding any vacancy in the number or in the absence of any member other than the president. Okay, this is just to emphasize the absence just now, where the chairman can go on with the case where there is any absence in the member. Okay, but the president, okay, must be there. Okay. So what is the qualification of a president and chairman? Okay, so they must have at least 7 years, okay, as an advocate and solicitor, peguam bela and pengacara, okay, within the meaning of Legal Profession Act. That means they must be a qualified person, okay, or they are a member of judicial or legal service of federal or state, judicial or legal service. That means they are at the Pejabat Penasihat Undang-Undang Negeri or Persekutuan. Okay, that means they are someone who has the legal qualification.
Madam,
Yes.
can I ask if the president and the chairman is the same person or different person?
Yeah, it looks like a different person. From the chart, is a different person. Okay, because where's the chart there? Okay, here only one president. Okay, and the chairman is for Peninsula Malaysia. Okay, there is one, and in KL, second Penang, Perak, and Johor. There's only 4 chairmen. Okay.
Branch.
But the section, I know the section is a bit confusing. Okay, it says that sometimes it's stated as a chairman, and sometimes it's stated as a president. Okay, but if you look at the what do you call the judgment, okay, actually I already take the steps how to find cases. So if you look at the judgment of the industrial court, it's signed by the chairman. So the chairman is the one who hears the case. Okay, so there's a two different person, president and the chairman. Okay, the chairman can, in case there's an absent in the panel, okay, panel in the chairman sitting, he can appoint someone, okay, but the chairman cannot appoint. Only president can appoint, okay. In case of vacancy, okay, it's not at the beginning. At the beginning, they are appointed by the minister, okay.
Okay, thank you, madam.
Okay, welcome. Okay, we already finished the qualification. Okay, immunity means kekebalan. Okay, section 24(1) says that every person appointed under section 21 and 23 shall be deemed to be a public servant. Okay, you know there's a difference between public servant. If you are a public servant, you are protected under the public general order provisions. Okay, so they are deemed to be public servant. Okay, and subsection 2 says that no member of the court shall be compelled to appear as a witness. Okay, so the member is the panel. You know, there's two panel. They cannot be a witness or party in any proceeding in relation to the act or matter performed by him as a member of the court. Let's say normally the panel for the workmen, okay, can be like the trade union member, trade union secretary, you know, they are representing the panel for the workmen, okay. And then panel for the employer will be like companies. If in that let's say on one particular day, the company have one case, okay, one case before the court. So the panel member who is a party to the case cannot appear in the court. Okay, you know, because what's the reason for that? He cannot appear as if he's a member. Okay, he cannot be a witness or party to the proceeding. Why is it? Can anyone think of a reason? Bias. Yeah, Nurul Aina say bias. So if you are panel and then you know your staff got a case in the court, how are you going to be a witness or are you going to be the panel? Okay, so you can be biased. Ada kepentingan. Okay, so you can be biased. Okay, because the panel has a role in the court. Okay, later when you study another topic, you know the panel. Okay, will inform the court what his opinion on the case. Okay, so if you got interest, you cannot be a party or witness to the case. Okay, then power of the court. Okay, so what the court can do. Okay, so section 29. Order any party to join, substituted or struck off. So let's say in a case 5 employee been dismissed, okay, all of them are in let's say in Perak, okay, so one case, okay, taken by one lawyer in Perak, okay, and of course you must file at Perak. You cannot find another court because if you want to file case, you must look at the subject matter where it happened. You must go to the jurisdiction, okay, in the same state. Okay, so another employee took another lawyer from another firm, so 5 of them take let's say three different lawyers, okay? So if it is different lawyers, the case will be filed separately by the lawyers, okay? So the court can join the case so that it can be in one hearing, okay? So you don't have to have separate hearing, so it can be joined, it can be substituted, okay? Substituted is be replaced, okay, or struck off. Struck off is to like batalkan, okay? You can also batalkan or struck off the case. Okay, then summon the parties or any other person who is in opinion is connected to the proceeding. Okay, let's say the employee stole a few maybe few what do you call few items, very expensive items from the company. Okay, and there's one eyewitness, so the court can summon the particular person who is connected to the proceeding. Okay, then take evidence on oath or affirmation and compare the production before it. That means ambil keterangan atas sumpah. Oath is sumpah. So you can take evidence. That means you normally you prepare an affidavit and you go to the commissioner of oath, Suruhjaya Sumpah, so that you sumpah in front of him lah. You take oath before the Pesuruhjaya Sumpah and then produce the affidavit to the court. Can be done. Okay. Then hear and determine the matter before it, notwithstanding the failure of any party to submit any written statement or in absence of any party. Okay. That means the court can still go on if there's a failure of the party to submit any document. Normally, it's not that one time. The court has requested maybe 3 times. The parties still do not submit the written evidence or written statement. So the court says, okay, we cannot wait. So they want to proceed. It can be done by the industrial court, or conduct the proceeding in private. In private means secara what do you call in bahasa? In camera, like this. Let's say it's regarding confidential documents. Okay, the court will sit for the hearing, but no person is allowed to enter the courtroom. Or in case of sexual harassment, okay, the case can go on, but it will be only the parties to the hearing. No public is allowed to enter, because a court normally any person can go and hear. Normally the person at the court or got any interest in the case will go to the court, because you don't have time to go to the court always. Or maybe a law student sitting, they want to hearing, they can go. But in case the case is in private, you are not allowed to enter. Okay. Then after consultation with the minister, call in aid of expert. So sometimes you want to know something more detailed, so you have to get the opinion of the experts, pakar expert. So you have to consult the Minister of Human Resource for the expert to give evidence in the court. Okay. Then at the end, the industrial court also can direct to do all things as necessary. That means all other things beside all that mentioned above, anything so that the hearing can go on smoothly. Okay. That's all about the power of the court. Okay. So I just want to know here the participant is already 59. The LLB student, are you still in my class, the 2 students? Okay, I've not checked the latest attendance. You're supposed to drop my class and follow the other lecturers' class. Okay, so I just letting you know, 2 persons, okay, which I already contacted, because I got 60 students, and now I supposed to have the most is 58. So I must check again the attendance. Is there any student who are from LLB program? Okay, so we continue. Any questions so far on the power of the court?
Madam,
Yes.
When you said that the conducts the proceeding in private, right? Is the panels also need to be there as well?
In real practice, just let you know that I do not know, is it so? But the panel will give some opinion to the chairman, because at the end you will see for the decision, he have to take whether it's like a majority or not. So maybe if the evidence is very confidential in private, they have to just go out from the room for a while. It can be like that, but I'm not sure in real practice whether the panel will be there hearing everything or he should go out. Okay, because normally like it's stated in private, so I'm not sure how far is it, just for the whole matter or just for particular instant where he have to give the evidence. Okay.
Okay, thank you, madam.
Yeah. Okay, so you see here, okay. So the award, okay, so the court shall have the power to make an award relating to all or any issue. The award here is the decision. We call it as an award. Okay, so you can give the award to all or any of the issue. Issues is permasalahan. You go to court, you want to ask for what you call compensation for dismissal, okay, or you want to ask for or what do you call for the back wages, or you want to ask for EPF which is not paid to you. Okay, so the court will decide maybe all or any of the issue depending on the matter, okay, whether there's any issue to be decided by the court or not. Okay, and then where the court is not unanimous on any question, the a decision shall be taken by a majority. That means if not all agreed to a question, okay, the court here, the decision, the award shall be taken by a majority of the member. Okay, so if there's no majority, like majority means you got 3 member for a panel of workmen, and 3 member for panel of workmen, and 3 member for the panel of employer. Okay, if there's a majority, that means let's say 5/6, 4/6, that will be the majority. Okay, if there's no majority, then the president or the chairman will decide the matter. Okay, that's why here the decision by the panel is also important here. Okay, that's why when it's in private, so I'm not sure if they didn't hear the important evidence, how are they going to decide? Okay, then the court shall make its award without delay and where practicable within 30 days from the date of reference. But normally it's not very fast. 30 days means 1 month. When you got matters at the court, it can be more than that, more than 30 days. But the law says that if possible, make it as soon as possible. That will be 30 days. Okay, then in making any award, the court shall have regard to the public interest, the financial implication, and the effect of the award on the economy and industry concerned. This is normally when, let's say, you want to pay bonus, the employer have not paid bonus last year, or maybe 2 years he did not pay. So the employees are not happy. Okay, so they filed a case at the industrial court saying that the employer have breached the contract. Okay, so if the court says that the employer must pay, if the court want to order the employer to pay, then the court will look at the financial implication. Is there any forfeit? No, normally bonus paid when there's a forfeit. So the employer says that we are not paying because we got no forfeit. Since last year, there's no forfeit, so we cannot pay. Okay, so the court will look at the financial implication, okay, and effect of the award on the economy and also industry concern. Okay, so if it is other court like magistrate court or session court, they will not look at this point. Okay, but industrial court will look at this matter. Okay. Okay, then other than that, the court shall act according to equity, good conscience, and also substantial merit of the case without regard to the technicalities and also legal form. Okay, so if you go to other court, the form is very important, the document is very important, you cannot make a mistake. But in this industrial court, the court will act according to equity. Equity means belas kasihan and also dengan suci hati. Okay, they will look at the relationship of the employer and employee. It's not for like if you're wrong, you have to pay for the breach of contract or like that. It's not like that. So you must, the court will look at many points here on equity and also good conscience. Okay. Then the court will also may take into consideration any agreement relating to employment practice. Okay, let's say in hotel industry, what are the practice? They got tips. So how tips are divided? So the court would take into consideration matters on practice also. Okay. Then the court in making it the award shall not be restricted to the specific relief claim or to demand made by the parties, but may include in the award any matter as it think fit or necessary. So when the matter goes to the court, okay, so the court study the case and see that okay, something has been missed out by the parties, so the court can also give an award on that. Okay, because if it is other court, they go very strict to what has been claimed by the parties. They cannot go outside the claim. But here, the industrial court shall not be restricted to the specific relief claim or demand by the party. So it can make also other award that the court think fit or necessary. Okay, and at last, the award may specify the period during which it shall continue enforced and may be retrospective. That means it can specify maybe for how long, 6 months, 8 months, or 24 months, and also it can be backdated. The award can be backdated. Okay. So, any questions so far regarding the power of the court? It's quite long under section 29 and also section 30. Okay. So, any question? No. Everyone is here or missing in action? Because I say sometimes we just leave the it's on and you are somewhere else or you are doing something but you're here. Okay, you must be listening. Okay, that's very important. Okay, good for those who are answered because if you're already here, at least when you got the PowerPoint, you can print and do some notes. Because studying at home is not easy because I also got my younger son. Okay, so I say it's very difficult, challenging when you are studying from home. It's like distant learning. You have to do everything yourself. Okay. Okay, good. For host will is I think it's already in the portal or maybe I already hide because I put the notes earlier. Okay. Okay, I'll make sure you can get the notes. Okay. Okay, what is the effect of the award? Okay, so when the award has been made, okay, so it shall be binding on all the parties to the dispute and all the parties join and substitute. Okay, so if you substituted somebody, substitute is to replace or you join any parties. Let's say there's one for the case and suddenly they notice that another employee also been dismissed but from that another department. Okay, they can join the case. Okay, so the award will be binding on the parties to the dispute and also parties join and substituted. So this must be done legally. Okay, you cannot assume. Okay, you must add the name in the case. Okay, that's why when you got some cases, the case have what do you call Ahmad bin Atan and others. The others is the other parties who join in the case. Sometimes you cannot put the name of 10 people or 10 workers together in one case. So you put others. Okay, any successor, assignee, transferee, or of any employer or trade union of employer or employee which is a party to the dispute. Sometimes in a business, today the case is going on. Somebody is the owner. After 1 year, when the case nearly towards the end, somebody bought over the business. Okay, so if there's any successors or assignee or transferee, also will be bound by the decision of the court. Then all workmen who were employed in the undertaking to which the dispute relates and all workmen who subsequently become employed. That means today the court says that, okay, employer have to pay bonus, okay, uh, starting from last year, 2019, that's the court decision. Okay, so it will be binding until, okay, even though the case was filed in 2018, okay, so 2020, okay, because the employee did not pay bonus 2019, so 2019 no bonus. The court says, okay, you pay starting from 2019 until let's say maybe until June this year, like that. Okay, so whoever been employed earlier this year also will get the bonus. Okay, so normally the employer will determine the percentage. Okay, then any members of a trade union of employer to whom the dispute relates and to which dispute the trade union is a party. Okay, so sometimes the decision will affect the trade union. Trade union is Kesatuan Sekerja. Okay, so if the decision affect the trade union, they also will be bound by the decision. Okay. Okay, so if the court already make the decision, okay, let's say the court make the decision, okay, can you appeal to the court, appeal the matter, okay? So here, the court that you can refer is High Court, Mahkamah Tinggi, okay? So if you want to refer any question to the High Court, okay, it must be question of law. Persoalan undang-undang sahaja boleh dirujuk ke Mahkamah Tinggi. Okay, so the question of law can arise in 4 ways. Okay, so it can be in the course of proceeding or to be determined by the court, or it's very important. It's important to refer to the High Court. Okay, and also there's any sufficient doubt that the matter must be referred to the High Court, but only on question of law. We got question of law and question of fact. Fact ialah fakta, so you don't have to refer. You cannot refer because the fakta or the fact is from both parties. Something to do with question of law, you can refer to the High Court. Okay. So it's not easy to refer to the High Court like the other court where if you are not satisfied with the decision of the let's say Session Court, you can refer to the you can appeal to the High Court. So for Industrial Court, we do not call appeal, but we call them as refer or reference to the High Court. You refer to the High Court so that the High Court will settle the matter on question of law. Okay, so here's one section. Okay, section 33. Okay, this section says that the Industrial Court an award, decision or order of the court, that means Industrial Court, shall be final and conclusive and cannot be that means shall not be challenged, appealed against, reviewed or quashed or called in question in any court. Okay, so the decision of the Industrial Court is actually final and conclusive. You can only refer the question of law to the High Court. Okay, remember, okay? So it's not like the other court that when it's a if the matter is at the High Court, you can appeal to the Court of Appeal, then you can appeal to the Federal Court. It's not like that. So the decision of the Industrial Court is different. Okay, it's final and conclusive. Okay. Okay, so who are the chairman, how the court have two panels, okay, what are the powers of the court, okay, how it can decide, okay. Now we see what matters can be brought to the industrial court, okay. So matters that can be referred to the industrial court, okay, is by the Ministry of Human Resource. Okay, that means you cannot file a case at the industrial court straight away. You must know that. In the other court, you can file at the magistrate court. So in magistrate court, it depends on your subject matter. What is your matter? You cannot suddenly file a case which is 1 million at the at the magistrate court. So you must know which court to file your case, okay. But in industrial court, you cannot file your case, okay. You must go to the which department? Can anyone mention which department? Arisa Surita, which department do you go if you've been dismissed by your employer? Which department? Okay, Department of Industrial Relation. Okay, it's not in your company. Is at the Ministry of Human Resource. Jabatan Perhubungan Perusahaan. Okay, so you go to the department and you file. It's not file. We call it as representation. Okay, representasi. Okay, so you what do you call, you fill in the form for the representation, okay, and the officer at the Jabatan Perhubungan Perusahaan or Industrial Relation Department will study your case and then call you and your employer for any conciliation, iaitu pendamaian if can. If cannot, then they will refer the matter to the Ketua Pengarah, and then if the Ketua Pengarah or the Director General cannot settle the matter, then the matter will be referred to the Minister. Okay, then only the matter, okay, will be referred to the Industrial Court. Okay, that means it's not straight away after the amendment. The employee can file. We have amendments still pending. Okay, so after the amendment, any employee can file straight away. Now you have to go to the middle person here. The minister is the one who will refer the matter to the industrial court. Okay, so it can be on what matter? Dismissal. That means pemecatan. You've been dismissed by your employer. Okay, or there's any trade dispute. Pertikaian, perdagangan or perusahaan, that means there's a strike, there's a picketing, okay, or what you call lockout, then the matter will be referred by the minister, okay. So these two are about the same, subsection 1 and 2. Or there's anything to do with victimization, that means you've been your rights as an employee been affected. You can also go to the industrial court, and then the industrial court will you go to the industrial department, and then they will investigate, and then the matter can be brought by the minister to the industrial court. Okay, so this matter, okay, this section 20 subsection 3 you can read, and then section 26 1 and 2 and 8 2a. Okay. So I have some brief. You will be studying this in dismissal topic. Okay. Section 20 is about dismissal. So if you've been dismissed by your employer, the workman here where a woman considered that he had been dismissed without just cause, that means without any excuse, he can make a representation in writing to the Director General to be reinstated in former employment. That means if you want to be reinstated, you must be reinstated in former employment. Okay, that means you are, let's say, junior executive. Okay, suddenly the employer is not happy with you. He give you a letter saying that you will be dismissed in 1 month time. Okay, so you are not happy with the dismissal. You say, okay, I have done nothing wrong. Why he want to dismiss me? Why he want to sack me? So you can file the representation after dismissal within 60 days. You got only 60 days to file the representation to the Industrial Relation Department, and the Director General will take steps for settlement. If there's no settlement, he will refer the matter to the minister. Okay, then the minister will bring the matter to the court. Okay, so that's how the matter at the industrial court work like. Okay, then here the minister will refer the matter to the industrial court, and then once he already refer the matter to the industrial court, he again cannot file in any court for wrongful dismissal, because sometimes it's like contract. You can also file at the high court or a magistrate court. So if you choose to go to industrial court, you cannot file in any other court. Okay, so then section 26 is about dispute. Okay, so minister also can refer the dispute. Okay, dispute, like I say, it can be like a strike, or it can be picketing or lockout. Okay, but we'll study this. We got one topic, separate topic for this. Okay, so all this is under the trade dispute. Okay. So there are cases that you can file straight away to the industrial court. Okay, so that is under section 56 for non-compliance of collective agreement or award. Okay, I think maybe you have heard about collective agreement. Have you heard about collective agreement before this? Any of the students? Collective agreement? No, okay. Faiz says no. Okay. So collective agreement is where the trade union, fight for all the workers, and then they get an agreement with the employer for better terms and condition. Okay, so if you got time, you just Google for collective agreement, a sample of collective agreement. Okay, so when you already studied the topic of terms and condition, you can see what is the difference between the terms and condition in the Employment Act and also in the collective agreement. So the trade union will fight for you. Okay, let's say they say that you must be given bonus. Okay, your maternity year leave must be, let's say, must be for maybe 100 days. Okay, your annual leave must be 30 days. Okay, so what has been stated in the Employment Act is minimum. So the trade union will fight for better terms and condition. Okay, so once they already fight for the terms and condition, they have to prepare it and get it the what you call cognizance of the court. Okay, so it must be an agreement where it is signed by both parties. Okay, so when both parties has signed, let's say the employer do not want to comply, that's what we call as non-compliance, then the trade union can go to the industrial court. Okay, here also is the same. So if there's any misunderstanding on the interpretation, okay, let's say the employer says that he will give a bonus every year. Okay, 5 years he paid. Suddenly on the 6th year he said, okay, he said, okay, our business is not good. Okay, he's not going to pay. But there's no terms in the collective agreement. Okay, the collective agreement says that he must pay but less percent. So the trade union can go to the industrial court to ask the industrial court to interpret. Is it correct? We still get our bonus but in lesser sum. Okay, or if it's any matter regarding point of law that we've seen earlier. Okay, you can also the parties can file direct to the industry court, okay. And also section 32 on variation of award of collective agreement. This is also everything to do with collective agreement, where the parties can file directly to the industrial court. Okay. And later we learn about what you call collective agreement. You can relate, okay, how it can be filed at the industrial court. Okay. So any question?
No, madam.
No. Okay. So now we go to labor court. Okay. So labor court is actually an office only, Jabatan Buruh. They have the Mahkamah Buruh there. Okay, so if we go to the labor court, it's just like an office, but they have the what you call a room where the parties, the employer and employee, can go and what you call negotiate their problem. Okay, and the officer there will be like the somebody who will determine okay the question regarding there's only few matters that can be discussed or can be settled at the labor court. So it's a mere arbitration. It's like a tribunal, okay. And it can be like quasi judicial administrative power, okay, under the Employment Act. The relevant statute is Employment Act. You can look at part 15 to part 16 here. Okay, so what matters can be settled at the labor court is where the section 69 give the authority to the Director General to inquire and decide any dispute between an employee and employer in respect of wages or other payment in cash. Okay, so not much things can be settled at the labor court. It's only regarding wages, salary, or other payment. Okay, or maybe it can be on the terms of contract between the employer and employee, or any other provision or provision on Wage Council Act. Okay, so here the Director General may order in a prescribed form. You only use form. Okay, for the payment by the employer for the sum of money as he deemed just. Okay, let's say the employee have done overtime for last 6 months, so the employer does not want to pay. So you go to this labor department because it's about wages and other payment in cash. Okay, so you make a complaint and they will investigate and direct the employer to pay. Okay, so it's different from industry court. Okay, so it can also include other matters, employee against any other person. It's stated here, okay, any other person. Also, they are willing to hear. Or it can be subcontractor against a contractor. Sometimes the contractor asks you to do some work to the subcontractor, but he do not want to pay. They also have the power. Okay, or it can be an case where the employee want to take action against employee. And also, let's say he's supposed to give notice. No notice of termination. Suddenly, the employee resign 24 hours. So the employer want to get compensation. He can do so. Okay, he can. So he goes to the labor department. Okay, so the labor department also can inquire and confirm and set aside any decision by the employer under section 14. Section 14 is where there's any misconduct done by the employee. Okay, misconduct. Example, let's say the employee has stolen something from the employer. So the employer have investigate the matter. Then he said that he want to dismiss the employee. So if the employee is not happy, he can also refer the matter to the labor department. Okay, labor court. Okay, for them to settle. Okay, then the Director General shall not cite the decision by the employee if Section 14 a decision has not resulted any loss in wages, any loss in wages of other payment payable to employee under the contract. There's a condition. Okay, so if he can here set aside, but he cannot set aside if there's nothing, there's no loss in wages. Okay, so Section 14 we will be studying later in misconduct topic. Okay, because it's quite difficult for you to understand everything because it's just like one slide. Okay, so normally when employee have done misconduct, the employer can dismiss him, can also give any other punishment. Okay, or it can also deduct the salary. Okay, so here if you got a complaint, the labour court can inquire the matter and see whether the decision of the employer is right or not. Okay, it's okay for me to continue without any, there's no break because not much I think left, not much slide left. Okay, I can continue.
Yes, madam.
Can, okay. So under Section 14, there's also other conditions that you must go to the Labour Department within 60 days from the date where the decision under Section 14 is communicated. Okay, so it's an offence lah if you do not comply with the decision. So if the employer have to pay any compensation, the employee have to comply. If not, he commits an offence. Okay, and the power of the Director General. Okay, the Director General, power is limited because sometimes the matter is already referred to the court, industrial court or any other court. So he cannot inquire into the matter if the matter is pending under the Industrial Relation Act or has been decided by the minister or has been referred to the industrial court also. Okay, so because once it been referred to the minister or industrial court, the Director General have to wait for the decision. Okay, then if you got any complaint regarding matters wages on wages, okay, here the Director General can investigate your matter even though your salary is above 2,000 but below 5,000. Okay, here only for the labour court, for the in case of inquiry, the amount of salary here is up to 5,000. Okay, the 2,000 is extended to 5,000 here. Okay. Then the Director General also may inquire and decide any claim concerning any indemnity where the contract service is terminated without notice or without expiry of any notice. Here, like I mentioned earlier, if the employee is supposed to give 2 months notice, he do not want to give any notice to the employer and he resign, the Director General also can inquire into the matter. Okay, then there's a penalty. So any person who fail to comply with the decision of the Director General shall commit an offence. Okay, and the offence here is stated can be a fine not exceeding 1,000. It's 10,000. Okay, and for every day you continuing for the offence, it will be like 100 ringgit for 1 day. So the Director General order, even though it's from the Labour Court, okay, is like a valid decision where the Director General may send a copy of the order to the Session Court or First Class Magistrate Court, and then it will be endorsed and it is enforceable as a judgment of the Session Court. Like for the money, no notice has been given, so the employee had to give notice. Okay, so he have to pay a lump sum. Let's say his salary is 4,000. So for 2 months notice, no notice given is 8,000. So the employer can enforce the judgment because it's like the judgment at the session court. Okay, I think we already come to the end about the industrial court and also the uh, labor court. Okay, I think there's some comments on the labor court. Why we call labor court is actually not a labor court. Okay, it's same thing in Singapore also. Okay, they do not have a labor court, but they call a labor court. It's just like the administrative office. Okay, um, you can Google and get the it's like some comment from a lawyer. Okay, so any question?
Madam,
Yes,
about the labor court, right? It's
yes,
supposed to handle the dispute about the wages between employer and employees, right?
yes.
Can we take these matters to the industrial court?
Okay, so let's say it also something to do with your dismissal. Okay, you've been dismissed. Okay, no wages paid. Okay, so I think the better court will be the industrial court. You don't go to the labor court because you go to the labor court. You can only their power is to investigate. Okay, you can see the money not paid to you. Which slide is that? Another one. Mm-hmm. Oh, sorry. Okay. So if you said that wages has not been paid till now, is it?
Yes.
Okay. So of course you can go to the labor court, but let's say at the same time no wages paid and you been dismissed. You dismiss means dipecat, dibuang kerja. Okay, so the industrial court have the power for reinstatement. That means you can get your job. The employer have no reason to dismiss you. Okay, so he dismiss you, saying that, let's say he's not happy with you. He got no reason. He got a new employee. Maybe his relative, and he's not happy with you. He got no reason. And he said, okay, now I want to give you notice, a 1 month notice. I want to terminate you. So the employer actually cannot do that. Okay, so now you want to take action against the employer. Okay, maybe he do not pay you the salary for the last month. Okay, it's better to go to the industrial court because you can file later for your representation. That means you go to the industrial relation department and you complain or you make a representation and you claim for back wages and also for the reinstatement. Reinstatement means you want your former job back. Okay, that's better lah. Okay, so you must know what is your limit for your case. Are you going to or you don't want to see your employer's face anymore, you just want the last pay. Okay, so you go to the labor court. Okay, I think it's better to work somewhere else, so let him pay my last salary. Okay, so you go to the labor court and claim for the money due to you. Okay, so you got two choice there. Okay, depending what claim are you making towards the employer. Okay, Ichin, you understand not? Hello?
Yes, madam, I understand now. Thank you.
Okay. Any other question here? A short, long question. Okay, so who sent actually this? This somebody asked me a question. So basically, we can say that the labor court specialize in wages and payment. Okay, anything due to you, any payment due to you, and also payment can be your salary, or it can be on bonus, or in lieu of notice. Okay, and the industry court specialize in dismissal, employee and employer relationship, and also the trade union together with the trade union here. Okay, and also collective agreement. Okay, dismissal, all these. Okay, so for industry court have a wider power compared with labor court. Okay, this is from Nurul Aina. Okay, any other question? Okay, so have you learned something today about industry court and also labor court? Okay, students. So
Yes,
you
madam.
must know that the industry court is for the private sector. So if you're a government servant, you've been dismissed, you cannot go to the industry court. Okay, so the industry court is for the government sector employees. Okay, because for the government sectors, they have to comply with the bab Perintah Am. They have their own code, okay, that you have to comply. Okay, and in government sector, it's not it's not easy for an employee being dismissed like the private sector. Okay, because they have the people control of an employee under government sector is like they have the pengarah, they have the what you call ministry. It's not easy to be dismissed unless you have committed like misconduct, very serious misconduct. Okay. Okay, so I think that's all for today's class. Okay, so we have not given you any work yet on the assignments because you are still preparing the question. Question is like we have to review and send to the committee. It's not that one lecturer give straight away.